Welcome to Patent Effect Podcast. This is the new episode of our podcast. And today we will talk about patent litigation scenarios in Turkey. So I'm in Berlin. So I just finished my 30-kilometer long distance walking on this weekend. So I'm feeling much more better. And I hope, and also I shared a LinkedIn post about my this long journey walking experience, and I'm definitely suggesting you to feeling a crystal clear vision and mindset. I'm definitely suggesting you to feel this walking experience. So today, as you know that one of our main sponsors at Turkish Landscape Report last year was DERİŞ from Turkey. So we are recording this podcast session with the support and sponsorship of DERİŞ. So I have a very distinguished colleague from DERİŞ. So I will introduce her immediately. But before starting our insightful podcast session today, I would like to remind you to follow our podcast channel on Spotify. It is very easy. It is just behind the corner, and then you can just click on the follow on Spotify channel, and you can also share this podcast session and also the previous sessions on LinkedIn, especially on LinkedIn and also other platforms. So I don't want to take it long as an intro. So you know me, this is Mustafa, and Patent Effect Podcast is starting. Welcome to our podcast session today. I'm with Muazzez Korutürk from DERİŞ today, so I can say hello to her and we can start our conversation. Muazzez Hanım, how are you?
Hi, I'm fine. And I understand that you're fine as well after your long walk during the weekend. And I can really relate with you how it is something very, very relaxing for you.
Exactly. Besides this long distance walking, I also implement a 5-day digital detox sessions, and I didn't use any WhatsApp or other social media during these 5 days. So it's a very, very insightful combination of long distance walking and digital detox. So I'm definitely suggesting you it's really helping to have a clear mindset. I think so.
Yes, yes, I totally understand you.
So we will have a really good conversation with you about the patent litigation scenarios in Turkey. Of course, we will define the patent infringement process in global or different jurisdiction, and what does it mean, how this process is going on. But before jumping to our insightful conversation, I would like to ask you, who is Muazzez Korutürk? And maybe you can also mention about DERİŞ and the establishment day, establishment year, how many people are working in the company. But before explaining the DERİŞ, I and our audience also would like to hear about you. How did you start this patent business? How is your experience? How many years are you working in this field? So on. So maybe you can mention about it.
All right. So I've started as an intern at DERİŞ Attorney at Law Partnership, and it was in 2011. It's close to 15 years right now. I decided to focus on patent matters, especially. It's been like 10 years now since I have been focusing on patent matters. And why I chose this area of expertise is that each case is a new case. You have to learn, you have to study, and you can really explore new fields, new areas. You can gain new visions, new perspectives in each case. That's why I actually chose patents, especially.
It's like a living organism, right? So every
That's right.
single case studies or every regulation change is affecting the practice. So it's much more,
Totally.
it's making this field more attractive and
Yes.
exciting.
And even each case is a different technical challenge as well for me because I don't have a technical background. I'm an attorney at law. But as an attorney at law representing your client in patent matters, means that you also need to educate yourself in the related technical area as well. Doesn't matter whether it would be a pharmaceutical matter or an IT or a software matter. You start from square one, and you learn the technical field from the beginning on. So that's what excites me actually. And each case is not similar to the other one.
Exactly. Each case are unique itself, like the patents.
Yes, that's right.
So maybe you can also tell a little bit about the DERİŞ.
Uh-huh. So DERİŞ is an attorney at law partnership, and it's established in 1912. So it's been over 100 years right now. And we are working as a team consisting of over 100 people right now, together with the trademark and patent agency as well, under the same roof. And DERİŞ is a law firm, is a company focusing on only IP matters. We can say that it's a one-stop shop concerning IP matters. Currently, it's the only IP firm who works hand in hand with European patent attorneys in patent litigation matters. That's what makes DERİŞ unique as well in patent litigation matters.
It's unbelievable. You said 100 years. 100 years ago, DERİŞ is established.
Yes,
It is super exciting. I know that DERİŞ is the oldest one, I guess, right? The oldest
yes.
IP law firm in Turkey in the IP field. So it's unbelievable. It's DERİŞ is this in the same age with the Turkish Republic.
That's right. When people, I mean, it might give the impression that a company over 100 years maybe, have maybe just not that dynamic as a startup people are thinking. But the reason why I love working in DERİŞ is it's dynamic. It has a vision going back 100 years, but also it uses this culture with a visionary perspective, to plan and also to shape the IP landscape here in Turkey as well.
It is super exciting to see this kind of old experience IP law firm. So congratulations for the founders, for all the employees, and I'm really honored also to have you as one of our sponsors and the supporters in our patent landscape report.
Thank you.
Let's dive into our topic. So we are talking about the patent litigation scenarios in Turkey, but of course the patent litigation is can be happen in any jurisdiction, but of course it depends on the national or regional laws and regulations. But simply we will talk about the patent litigation scenarios in Turkey. But of course our listeners can be from out of the Turkey, in Turkey. Maybe we can start by making the definition of the patent litigation process. So there is a
Yes.
patent owner, and there is another company or the individual who is infringing the patent rights of the patent owner, and then possible litigation process is starting. So what I am considering, or what I'm wondering, that what are the options of patent owners and the litigator in terms of the patent litigation infringement process. Maybe we can make this definition and the process as a nutshell.
All right. So, what triggers the process to start is actually, and usually in Turkey, is that patent owners become aware of an infringement against their patent rights in Turkey. So, usually, the patent owner has a suspicion that the patent right of him is infringed. And so this starts the process. But what if you become aware of a possible infringement of your patent rights? What can you do? There are different types of actions which you can use. but which I strongly recommend to be built according specifically unique for each matter, is the patent owner may send a cease and desist letter to the possible infringer, requesting the seize or the use of the patented product or the process, or may request some information from the infringer concerning that suspicion in order to clarify the fact whether the patent rights are infringed or not. Another option is to file an evidential action for securing the evidences or in order to be able to determine whether there is really an infringement or not. There is a possibility for filing a main infringement action. And also a main infringement action can file together with compensation claims as well. But then again, there are also some options which may be used by the adverse parties as well, by the third parties who are under the suspicion to be infringing the patent. And these may be non-infringement actions, claiming that their product or that they're claiming that their actions are not infringing the patent rights of the patent holder, or they may, of course, file an invalidity action against the patent as well.
So these actions are mostly same for the all jurisdictions, right?
Yes, we can say that there is a point of harmonization with regard to these options.
So as a patent owner, if I see any kind of infringer, the possible ways as a starter point can be the starting a negotiation, right? So sending a letter to the infringer, we can say that stop. Or if you want to produce, let's have a deal, a licensing deal, right?
Yes, that is the utmost goal we are aiming when we are sending a letter to the adverse party. But generally, I can say that the Turkish people are not so inclined in settling the matter at the very beginning, or when they receive a letter from a patent holder, the adverse parties in Turkey are more like they disregard the letter. They don't want to reply, or sometimes they don't reply to you back, but they cease their actions. This is also a possibility. But it is also possible if you have a patent which is infringed, which you think it is infringed, and you send a letter out to a third party, it is also possible that the third party may simply file a non-infringement action or an invalidity action against your patent upon receiving that letter. So it depends.
I understand. So for the infringer, there is a kind of a counter action, which means
Yes.
that invalidity of the patent. So they can claim that this patent has no right to be granted patent. So they can file a invalidity case, right?
Yes, so that's why it is important to look into the third party, look into the adverse party's profile, or so to say, persona, in order to consider a strategy before taking an action.
But of course, if the infringer is filing an invalidity action, so it makes the process is much more longer, right? Or it depends.
Yes, I would recommend to companies who are patent holders to build up a possible strategy before taking an action against any possible infringer. This is because if you face an invalidity action, you fall back to a defense position, and I really don't like that position to be in defense against a possible infringer. So that's why I recommend to plan at the very beginning each step of the action in order to preserve the position of the patent holder.
So you need to create your plan A, B, C, D before filing the lawsuit case, right?
Exactly. That's like, in patent prosecution as well. you draft your claims, but you always have a plan B, plan C. You always have a fallback position in any case. So that's the same in patent litigation strategies as well.
Exactly, because there are lots of ways and different sub processes that can be taken by the infringer as well. So maybe we can talk about what types of actions can be filed in this patent litigation process. You said that there is a kind of evidence
Yes.
lawsuit, or it's a combination with the evidence plus blah blah blah, so that can
Mhm.
be separated actions and the combined actions, right? Can you explain this a little bit more?
Yes. So it is an evidential action. It's similar to the actions in Germany or in the US. It's an ex parte action. So the adverse party is not notified with that action. You simply file a request before the court and request the court to visit the premises of the infringer in order to secure, to determine the actions and evidences of the possible infringer. This is also a type of action which the patent holder may use if the patent holder has any suspicion whether the patent is infringed or not. I mean, you cannot be 100% sure, but you have some doubts about the infringement, and you can request from the court to visit the premises and to secure those evidences to determine those actions of the adverse party. So the patent right holder files a request before the court. The court assigns an expert concerning the related technical field of the patent. So if it's a chemical compound, then the expert will be a chemical engineer or a professor with regards to that technical field. And then you visit the premises together with the court appointed expert. And sometimes the judge joins that determination as well.
I think this is the most exciting part, because 5 or 7 years ago I was acting as a witness expert in this kind of infringement cases. And
Mhm.
the exciting part is, visiting the company's premises with the judge without any notice before, and they are really surprised, and they need to open the doors, and then you are just, keeping the products or any materials, and then you are collecting, and then as an expert, you will write the expert report to the judge. So this is the very important part, I guess, for the evidence collection, right?
That's right. And this is the part where you also see the inside of the case as well, because you are visiting the premises of the adverse party. If it's a process patent, then you are also able to see the production line of the adverse party. You have the possibility to observe all possible facts and actions of the adverse party. So that's a very important type of action, actually, and which I personally also like very much, because it's also something exciting. The adverse party is not notified beforehand. They don't know what happens, but you explain them. And it gives also the opportunity to the plaintiff's attorney to get in touch with the adverse party. So you can also trigger a negotiation during that visit to the premises. You just start a communication with them during that process.
Exactly. So regarding this patent disputes, do you have any, the data or information about in which industries or any sectors that we mostly commonly, see these patent disputes arising in Turkey or in global way?
Okay, so in Turkey, the patent disputes concerning the pharma sector is very high. So the numbers are very high concerning pharma patents in Turkey. But then it is also including biotechnology, genetics patents as well. Then the number of cases in Turkey filed is followed by mechanical patents. And these are usually the patents concerning the automotive sector, the textile industry, and also the furniture industry as well. And it's not a coincidence that the other sectors are automotive or the textile industry, because these industries are improved in Turkey. So Turkey is commonly known with its semi-products for automotive. And Turkey is also very improved in the textile industry as well. So it is not a coincidence that these sectors are, that the pharma sector is followed by these sectors when it comes to patent matters.
So it's not a surprising thing because the pharma industry is in the first place that you also mentioned, because Turkey is a full of generic drug companies. So there is a possibility to infringe the originator patent, right? So I think these kind of patent disputes are between the generic Turkish generic companies and the originator foreigner companies like the United States or Germany or Swiss companies. I think so.
That's right. That's right.
So in terms of the arising areas like biotechnology or the biological drugs or generic inventions, is there any patent disputes in this field in Turkey as well?
Yes. For example, DERİŞ represented a company in the genetics field. It was between an originator and a generic company. Both parties were outside of Turkey, but Turkey was a very important market for both the originator and the generic company. And it was a multi-jurisdictional patent litigation matter. So there are really very interesting cases which go on globally, as I said, multi-jurisdictionally, but also including the jurisdiction of Turkey as well.
I see. I understand. So in the patent litigation process, I think the trade fairs are really important. And as I remember, Derish is very active on enforcing the patent rights at the trade fairs. So how can this process is going on? The trade fairs. There are lots of companies who are producing the different products. Some of them patent owners, and some of them are the infringers, which are showing their new products. So how do you acting in this kind of events in terms of the litigation process?
Yes. Turkey is a preferred country when it comes to international trade fairs because it's in the middle of Europe and Asia. And there are really very important international trade fairs here taking place in Istanbul. And the attendees are also global companies, but Turkish companies also. What we do is in these types of actions, when there is an international trade fair, we monitor this trade fair in respect of its attendees. And the attendees also have websites. We first monitor their websites and see whether they are possible infringers or not for patents. And afterwards, we visit those trade fairs. We visit the booths of the third parties. And if we find any infringing products or any infringing promotional material at the booths of the third parties, we then take actions against those third parties during the trade fairs. So I know that there is again similar type of actions in Germany. And in Germany, the court usually renders a preliminary injunction order for the removal of those infringing goods during the fair. Unfortunately, this is not possible in Turkey. But what we do is, when we take actions against third parties during the trade fair, we serve them cease and desist letters, we file evidential actions for the determination of the infringing goods at the booth of the third parties. Our main goal is to remove those infringing material during the trade fair. And this is a type of action in which we are successful 100% or close to 100%, because usually when we take those actions during the trade fairs, the third parties remove the infringing products and the promotional material referring to the patent's protection.
So in this process, you are not filing a kind of or not filing. You are not sending a letter before the trade fair, right? So you are doing these actions trade fair during the trade fair, not before.
Yes, we don't take any actions before the trade fair, because what we want to see is we determine those possible adverse parties before the trade fair, because there is an attendee list published. And we sort of have a list of possible infringers before the trade fair. And when the trade fair opens, we visit the trade fair, we visit the booths of the possible infringers, and then we take actions during the trade fair. We don't take any actions before the trade fair. So this is also a surprise effect to the third parties as well.
I understand. So it brings us the evidence collection before the trade fair, right? So you are collecting all the evidence materials and the, in the discovery phase. So is it possible also to collecting the evidence before initiating a lawsuit? So, for example, in Turkey or in other some jurisdictions, because there must be a kind of a formal mechanism for this pre-trial evidence collections. Is that correct?
That's correct. So the pre-trial evidence collection, actually the trade fair serves for a pre-trial evidence collection, because during the trade fair, if those infringing products are displayed during the trade fair, we also file an evidential action before the court and request the court to go to the booth of the adverse party and to collect, to determine that evidence. But let's say there is no trade fair and you have a suspicion about an adverse party. Again, you can request the evidence collection within the evidential action. So then the evidence is collected by the hands of the court, and the evidence is kept under the custody of the court if the patent holder wishes to file a main infringement action.
So just let's imagine that as a patent owner and with the help of my lawyer, we collected the evidence, and I created or we created the evidence of use claim charts, and then I am sure that there is a infringement. So how does the litigation process unfold in this practice?
So you are asking, there was no evidential action, but we collected the evidences by ourselves and then filed the main infringement action, correct?
Exactly, exactly.
Okay. So in this case, the court again takes into consideration the collected evidences, but then you might have an issue with regard to the reliability of that evidence.
Hmm.
So this is why we usually request the court to collect those evidences in the name of the patent holder, because in that case, these evidences are not arguable by the adverse party.
Yeah, it's understandable. So the court is doing that evidence discovery part as as a legal process. So that's why the opposite party, the infringer, will trust or can trust on the results of evidence part.
Yes, because in other cases, let's say I am a patent holder and I went to a store, purchased an infringing product from the store with the invoice, of course, and then submit that evidence to the court and claim infringement. It is again it's taken into consideration by the court, that evidence, but it might be arguable by the third party. So why arguing about the reliability of the evidence when there is another option to gather it through the court? And while gathering it, maybe you also can communicate with the infringer during that process of collection of evidences. And maybe you will end up with a settlement before going into a lengthy litigation. So that's why I recommend to keep the collection of evidences apart from the main infringement action.
I understand. So it can be very helpful for the negotiation as well. So let's come back to the preliminary injunction. So you mentioned that the preliminary injunctions are very common in Germany. So
Yes.
what I am considering that maybe we can talk about at which stages of these the proceedings can preliminary injunctions can be requested. It's very important because it's very powerful action as far as I know.
Yes. So every patent holder, I know that every patent holder would like to obtain a preliminary injunction order at the very beginning of a court action. And this is what we are trying to do when we are representing our clients. But in Turkey, it is a little bit more difficult when it comes to complex patent cases. The reason for that is that the judges don't have any technical background, and the judges are evaluating the technical side of the patent case through the court-appointed experts. A preliminary injunction can be requested from the court at any stage of the case. It is also possible to request a preliminary injunction order to seize the use of the adverse party of the patented rights at any stage, but also after the filing of the evidential action. So once you file the evidential action, you request the collection of the evidences, and once the court-appointed expert issues its report and states that there is an infringement after the evaluation of the collected evidences, then you are also able to request a preliminary injunction order at the end of an evidential action. But the condition in that case is that you need to file a main infringement action upon the execution of the preliminary injunction order. So you need to file a main infringement action as a complementary action after the issuance of the preliminary injunction order. But let's say you have filed a main infringement action and you requested a preliminary injunction order. What happens in that case? You file the main infringement action with the request of a preliminary injunction order. The court reviews your preliminary injunction request, but as I said, since the judges don't have any technical background, they will request an expert report for seeing whether the patent is likely infringed or not. So let's say the court referred the file to the panel of experts, and the panel of experts said that there might be an infringement. In this case, it is likely that the court would issue a preliminary injunction order. So this is a really likable scenario. But in some cases, the judge renders a decision saying that the preliminary injunction request will be evaluated after the expert examination, which most likely takes around 8 to 12 months upon filing the main infringement action. So you file the main infringement action, and the court proceeds with the action. And once the action reaches to the expert examination phase and the expert report is submitted, then the court might issue a preliminary injunction order. And there are also some scenarios where the court requests the patent right holder to deposit a guarantee payment in exchange of a preliminary injunction order. This is because the patent right holder prevents the adverse party from producing a certain product and is preventing the commercial activities of the adverse party with regard to that patented right, which might be infringed. So this is why usually the courts decide to the payment of a guarantee bond for patent right holders if the court issues a preliminary injunction order.
This is a very deep topic, right? So
Yes.
maybe, but for the audience who are wondering the details about the preliminary injection, it's very difficult to pronunciate. Preliminary injection. So we also recorded another podcast session with the experts from DERİŞ. So our audience can find this podcast episode on the description side. So we talk about preliminary injunction in Germany and Turkey. We made a comparison deeply. So we have a special podcast session for this specific topic, by the way. So maybe we can talk about the negotiation part. So you already mentioned that before filing a litigation case, the parties can negotiate before the court. So, but I'm wondering how these the settlement negotiations are handling during the patent litigation process. So not before filing a litigation, during the litigation. Do you have any
Uh-huh.
experience on this kind of settlement negotiation? How the methodologies or what kind of methodologies are used? So it is also dependent on the valuation topic as well.
Yes. So usually, actually, most cases, I mean, yes, I can say most cases end up with a settlement when it comes to patent litigation matters, because it's a really lengthy process. And upon a certain stage during the court action, one party understands whether the court action will be lost or which party will lose the action, which party will win the action. It becomes obvious after a certain time upon the filing of the action. So this is why the parties want to settle the matter before it comes to an end. And a settlement in patent litigation matters could be done at any stage of the court action. There is no requirement to settle the matter at a certain stage, but you can settle the matter at any stage. What comes up is one party approaches the other one and asks whether there is a possibility to settle the matter. I can say that there are pretty much good number of cases where the patent litigation has ended up with a settlement. And in my personal view, a settlement is a win-win, actually, because this is why I also prefer to file an evidential action before the main infringement action, because as I said, you may settle the matter before going into a lengthy court action. And this is also the case during the patent litigation matter as well. So, of course, in settlements, there is a negotiation for a there might be a negotiation for a certain sum of money, but there might be a settlement which does not concern any money, but the use of the patents or the exchange of rights between the parties as well. It depends on the specifications of the case. You mentioned also the valuation of the patent. This is something, of course, if during the negotiations the value of the patent comes in question, parties exchange their trade documents, their past use of the patents, and it's something calculated, and it's something where both parties come to an agreement of a certain amount to be paid to the patent right holder or vice versa.
So I'm just wondering that I'm feeling, acting as a patent owner. I'm in the patent litigation case, and I see that it is obvious that I will win as a patent owner. So the infringer will use. But the question is, why should I settle as a patent owner? So I can wait the result of the court.
Okay, let me ask a question about that. You're a patent right holder, and it's obvious that you're going to win the case, but the adverse party approached you for a possible settlement. What would you reply?
Of course, as a person, I will always prefer a win-win scenarios in the negotiation. But if there is a possibility to win or to get a much more higher amount of damages at the end of the court, why I am settling with the infringer? I can reject.
Yes, you can. But what I experienced so far is, court actions take a long time because there will be an appellate stage of the court action. There will be a Supreme Court stage as well, and this will take a certain time also. So if I would be your attorney in that scenario, I would recommend you to settle the matter. Of course, with regard to the valuation or with regard to the money you will get after that settlement, I would arrange it in a way that you wouldn't have to wait for the court action to finalize, and that gain of time would return to you as a profit.
Exactly. I totally agree with you. So it reminds me that there is a value of money in the time, of course. So you will get the time rather than waiting the results of the court. So you will get an advantage of shorten the
Yes.
time by having a settlement agreement with the infringer. Okay. Okay, understandable. Win-win. It's a still win-win scenario. So how about the damages? As you said that the both parties should calculate the damages by
Yes.
showing the invoices,
Mhm.
the income that they are
Mhm.
using the patent in the product. So there must be a kind of damage calculation by the both parties or the judge or the court or the experts. So how this process is going on in this patent infringement cases?
Okay, it's actually pretty much similar to the calculation in our other jurisdictions. There are three types of calculation methods determined in the IP code. One of those methods is that the patent right holder has to submit its trade records in order to show how much profit it would gain if the infringement of the adverse party would not happen. So in that case, as I said, the patent right holder has to submit its trade records to the court in order to enable the court for a possible calculation of the loss of profits the patent right holder has suffered. In method B, there is the profits the infringer has gained from that infringement is calculated in method B. So in that case, the trade records and the invoices of the infringer is then evaluated during that calculation method. And there is another third option. In the third method, the license fees of the patents are then calculated. So the court will evaluate how much damage the plaintiff has suffered and how much profit the patent holder would gain if the infringer was a licensee of the patent. But in that third method, the court usually asks for an exemplary license agreement signed with another third party by the patent right holder.
Yeah, there are lots of ways to calculate.
Yes.
My favorite is relief from royalty method.
Uh-huh. Why is it your favorite method?
Of course, if the patent is used in the product, so there is an infringement, so the infringement party has already sell the products in 1 year, 2 year, whatever it is, and if the patent owner can define the royalty rate of these patents, and then they easily calculate the possible income during these infringement years based on the revenue, annual revenue,
Mhm.
and with calculation of the royalty rate. But the problem is, or difficulty is, defining the royalty and or agreement of the optimum royalty for the patent. But every patent is unique, so you cannot make a simple benchmark with the other similar patents. That's why defining the royalty rate for the patent and the calculating the damage based on the relief from royalty might be the reliable method.
Yes. In that method, the challenge is to have a similar license agreement.
Mhm.
I mean, if you have already some licenses for that patent, and if you have a certain amount of royalty fee you gain from those licenses, then it's easy to calculate. It is, of course, then it's logical that you choose that method. But if you don't have any exemplary licenses for that infringed patent, then that becomes a challenge to convince the court about the rate of the royalty fee.
Exactly. That's the point that we solved already in our AI based patent valuation platform. It's another
Uh-huh.
story.
Okay.
Before coming to end of our episode, so I would like to talk about the complexity of the cases. As you know that, and most of the people says that, oh, patent litigation process is a so long journey, so I don't want to get in this process, let's negotiate beforehand. So, and the time of this patent litigation is also depends on the complexity of the patent or the complexity of the case.
Yes.
Is it a major major factor that defining the time of the proceeding? Do you have any particular example, or is there any particular sectors or industries which which becomes prominent?
Okay. So I can say that pharma litigation is a relatively long journey in Turkey. The reason for that is, as I said, that the judges don't have a technical background and that the file is referred to a panel of experts. And sometimes, in some cases, in very complex cases, the case file is being referred 3 times to different panel of experts, and it becomes really a challenge to find those exact experts. And then it becomes also a challenge to explain the technical aspect of the case, both to the court and to the experts as well. So then it becomes really complex. And that's why I can say that pharma litigation matters are relatively longer than the other technological fields.
Because it's a chemical complex chemical compound, so it requires a kind of technical expertise in the field, both ip and chemical expertise. So we can say that if the patented technology is a complex or deep high technology, so the patent litigation process can be longer, right?
That's right.
Okay, good, good. So we covered lots of topics and subtopics for the patent litigation scenarios. And also we mentioned preliminary injunctions as well, negotiations, settlements, and also damage calculation. It's a pretty comprehensive episode. And thank you so much for your insightful inputs for this episode. Before closing, Moazes, do you have any kind of takeaways or the suggestion to our audience regarding this patent litigation topic?
Well, as I said during the whole podcast, actually, patent litigation is something really complex, and it's something to be handled with people who have technical expertise. But my recommendation would be to, consider the whole aspect of a single matter and to go on a journey very well prepared in order not to face any surprises in that journey.
Exactly. Plan A, Plan B, Plan C, D, as we already
That's
mentioned.
right. That's right.
Exactly. So, for our audience, if you have any questions about this patent litigation process, or if you need any kind of expertise on this, so you can find Muazzez Koritürk's LinkedIn profile on the description, and also you can find the website of DERİŞ company, so you can get much more deeper information about that. And also you can follow or you can read very comprehensive articles written by experienced experts by DERİŞ. You can find it in different platforms as well. So if I can find, I can also put on the description site. So it's almost 1 hour, Moses. Thank you so much.
Thank you. It was a pleasure to take place in this podcast, which I really like to listen to personally.
Thank you so much. Thank you so much, and I hope we can meet in person in the some of following events in Turkey or in Europe in others in any kind of cities in the world. So
Hope
thank you
so.
so much, Moses. Thank you so much, Derish, by supporting this episode as a sponsor and supporter. And let me close the session. So we completed our insightful episode with Muazzez Koritürk, and we mostly talk about the possible scenarios, possible patent litigation scenarios in Turkey. So please remember that we recorded this podcast in the sponsorship of DERİŞ company, DERİŞ IP. So you can find the website of the company on the description site. I hope you also enjoyed during this session. It's almost 1 hour and full of insights, full of technical information during this process. I think you also enjoyed like me. So please don't forget to follow our Spotify channel, Patent Effect Podcast. You can find it easily on Spotify, and you can just click on the follow. And of course, we will be very happy if you can share this episode or the previous episodes especially on LinkedIn and the other social media platforms. So hope to see you for the next episodes and wish you a great day. See you.